Yes, good evening to the aspirants of the JCJ 2022, the main, and here the free online classes are going on the main, for the main examination. Yes, read what I posted on the screen. Anyone can unmute and read.
Evening to the aspirants of JCJ 2022 State of Telangana main examination hosted by KSB and Professor Hussain. Very important dying declaration Indian Evidence Act. Host Professor Dr. Mohammed Saheb Hussain. Limitation bars the remedy but not the right. Discuss this topic will be death by the Sri Kolikonda Sharad Babu. Writinglaw.com. Sir, can you visible the screen, sir? Last line is unable to see, sir.
It's unable to see. Anni danamula kanna vidya danam minna. This is our slogan. Repeat. Repeat.
Anni danamula kanna vidya danam minna.
I
This is our
appreciate. Appreciate. Yes, sir. And yesterday that we are dealing about the dying declaration, there I already made it very much clear that section. Why you are not giving the answer?
Sir.
Section. Why you are
Section
keeping
32,
silent?
clause 1. Section
Repeat.
32, section 1 of Indian Evidence Act. Section 32, clause 1.
Section 32, clause 1 of the Indian Evidence Act. That is the appropriate and right way. But in the many places, you will find, see, here I am showing it. And here he said, subsection 1 of the section 32 of the Evidence Act. Did you see it?
Yes, sir.
It is not subsection 1 of section 32. It is
Section
clause 1 of
32,
the section 32 of the Indian Evidence Act. Is it clear?
Yes, sir.
Only Professor Hussain could make such a distinction. It is an open challenge. Okay, anyway, let us come to the point because yesterday that we dealt Tapinder Singh versus State of Punjab, where it is very much made clear that the dying declaration is admitted in evidence by way of an exception to the general rule against the admissibility of the hearsay evidence on the principle of necessity. So, a necessity made the court to see that justice should be done when a person who is on the deathbed could not come and give the evidence, but a magistrate goes over there, take the declaration from the man who is going to die, and that is called a dying declaration, which is a valid, even though it is not against the admissibility of the hearsay evidence. So, dying declaration is the last statement made by the person at a stage when he is in a serious apprehension of his death and expects no chances of his survival. And we also discussed yesterday, suppose if he survived, what would be the position? So, and if it is not survived, okay, it is valid, well and good. And let me see the same thing that we observed there. When a version given by the deceased as a dying declaration is supported, see the cursor where I am reading, and corroborated, because it is a repetition, corroborated by other prosecution witness, there is no reason for the court to doubt the truthfulness of such a dying declaration. So it is observed in the, what is the name of the case law? It is observed in the read.
Sudhakar versus State of MP.
Yes, that is the case law within parentheses 2012 and the 7th volume Supreme Court cases 569 page. The another citation also the 2012 Supreme Court cases Criminal Law Journal 430, because Supreme Court cases having the both, sometimes they have the separate criminal law and sometimes the fixed or combined of the both. So now deathbed or dying declaration are constantly admitted in evidence. So mostly constantly admitted. The principle of this exception to the general rule is founded partly on the awful situation by the dying person, which is considered to be as a powerful over his conscience as the obligation of an oath, and partly on a supposed absence of interest, a person on the average of the next world. Because generally the say is that a person who is on the deathbed are going to die, and he will always reveal the always reveal the please fill up the blank. Say I don't know, or say pass on. Participants, a person who is on the deathbed always reveal the reveal means say.
Truth.
Why you are taking so much time? Because we discussed earlier.
Yes, sir.
He always reveal the truth, which dispenses with the necessity of the cross-examination. But before such a declaration can be admitted in evidence against a prisoner, it must be satisfactorily proved that the deceased at the time of the making them was conscious of his danger and had given up all the hope of recovery. Of course, this goes with the evidence how whether he will be going to recover it or not, whether he is going to die or not. So that is R versus Perry. It is decided that is a 2 King's Bench 697 page. And this may be collected from the nature and the circumstances of the case. It depends upon the circumstances of the cases and decided whether it is genuine or not. But the most of the cases that we will say it is a genuine, because at the deathbed no but reveal the
truth.
No, but he only reveal the truth. That is the point. But sometimes some people want to make the revenge of it, and that's why they will take it. And even though the person is not present over there, but they will take the name of a person, and it is informed to the magistrate. At that instance, corroborative evidence and the prosecution witnesses make it clear that whether it is having a genuineness or not. So that is will be counted and be considered. Although the declarant did not express such an apprehension, of course, he has given the grounds for it is. Excuse me. It is not essential that the party should apprehend the immediate dissolution. It is sufficient if he apprehended it to be the impending. Of course, they say the apprehension would be there. How far it will be taken into consideration? Because generally the people say that he will be no more in this world. That's why they would like to reveal the truth. The Criminal Law Amendment Act of 1867, of course, 30 and 31, of course, this is a Victorian Act. It is not applicable to us because it's an English case law. So, what I want to say is, you have to answer the question depending upon the marks allotted for that question. So, that is the more important factor which I want to share with you. But when you ask for the lengthy question, then the writing would be the entirely different. Like here, I made the dying declaration under the Indian Evidence Act. There, I made it very much clear that is Section 32, Clause 1 of the Evidence Act deals with the statement of relevant fact, which may be either written form or said verbally by a person. Suppose if they are not written form or not verbally, can it will be indicated by the gestures? Give me the answer. Gestures or gestures, spelling Gestures. If you don't know, you say pass on. But I told you to read and come to the class. Because it's not a one way. I teach and you listen. No, you participate it. What is the case law? Famous case law. Where the neck is slit.
King versus Abdullah.
Yes, in that case law, a neck was slit. Incision is made. He could not speak over there. Hence he made with the gestures. That is the Emperor Regina versus Abdullah. That is the case law. Where the gestures also can be considered. Am I right?
Signs and gestures are also considered as a dying declaration.
Yes. So now the question is, number one, who is dead? Number two, who can't be found? Number three, who is incapable of giving evidence? Number four, bullet, whose attendance cannot be procured without an amount of delay or expenses which under the circumstances appears unreasonable to the court. In this, of course, these are the areas or the situation where the dying declaration could be considered. Now, dying declaration meaning we already read it and we made it very much clear in the Sudhakar and other verses. The state of Maharashtra, dying declaration was defined as follows. It is not the subsection 1, it is class 1. Is it clear? Class C-L-A-U-S-E, class. Class 1 of the Section 32 of the Evidence Act provides that when the statement is made by a person as to the cause of his death or as to any circumstances of the transaction which resulted in his death, being a relevant fact, is admissible in evidence. Such statements are commonly known as dying declaration. In another case law, Ram Bihari Yadav versus State of Bihar. Can anyone unmute and read this case law loudly, keeping the electronic gadget very near to the mouth? Quick!
Justice Syed Qadri explained the dying declaration as a dying declaration
Keep your mobile very near to the mouth. Then speak.
A dying declaration made by a person who is dead as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of his death comes into question, is relevant under Section 32 of the Indian Evidence Act and is also liable in evidence.
Also admissible. So, a dying declaration made by a person who is dead. Sir, how could a man who will make declaration? No, I say before his death, before his last breathing. And he is dead as to the cause of his death. And if he shows that the cause of his death as to any of the circumstances of the transaction, in which transaction he was there, and the context which he make it out, and which is resulted in his death, in case in which the cause of his death comes into the question, and they are considered the relevant, and that statement before his last breath, what he says, what he conveys, what he reveals, what he writes, what he gestures, what he represents is said to be a dying declaration in the admissible in evidence. It is to be noted that the dying declaration is indirect evidence, and so it is an exception to the rule against the admissibility of the hearsay evidence. So hearsay evidence is not directly taken into consideration, but with the corroborative with the other evidences, hearsay evidence would be considered. And in the same way, the dying declaration is an exception to the hearsay evidence, so it will be the admissible. So elements of dying declaration, when you want to say, elements of dying declaration are illustrated under Section 32, Clause 1 of the Indian Evidence Act. According to Section 32, Clause 1 of the Indian Evidence, dying declaration is a statement. First bullet, read.
Written or verbal.
Very good. Second bullet.
Of relevant facts.
Third bullet.
Made by a person who is dead.
Yes. These are the three conditions are fulfilled. Either it should be a written or verbal, but also goes with the gestures. Of relevant facts, the situation, transaction, where he was died, and made by a person who is dead. After making such a statement, either written or oral by the gestures, and later he takes the last breath at the time, these are the three situations where we can say that such a statement is relevant when the statement is made by a person as to, number one, the cause of his death, if he shows. Number two, bullet, any circumstance of the transaction that resulted in his death. Such statements are relevant. And here again the bullet they have given is whether the person who made them was or was not at the time when they were made under the expectation of death. So, we will consider whether he is given at the time, at the deathbed or not. And whatever may be the nature of the proceedings in which the cause of death comes into the question, it may be a criminal proceeding or a civil proceeding or the family dispute, and whatever the proceeding would be there, whatever the transaction is there, whatever the context would be there, if a person is died. Is it clear? Of course,
Yes, sir.
yesterday the Sir Venunath has made it clear, sir, what is the distinction between the English law and Indian law? So, dying declaration on the English law, in English law, dying declaration is relevant, but two conditions are required. What is the two condition? Read, anyone can unmute. The other participant should have to read. Please give
The
the chance to
person
the other
must be-
participant.
The person must be in expectation of death. The nature of proceeding must be criminal, and the accused is charged with murder of culpable homicide.
But he said the criminal, the word they used is, the person must be in the expectation of death. The nature of the proceeding must be criminal, they say English law. And the accused is charged with the murder or the culpable homicide. This is another condition they made it. And but in India, even civil cases also will consider the dying declaration. Am I right? Am I right?
Yes, sir.
In civil matters, of course, when the killing is there, injury is there, then naturally it will be turned to the criminal matter. Because causing the death is a criminal offense, even though it is arising from the civil matter. Am I right?
Yes, sir.
Suppose a land dispute is there. Can the land dispute is a criminal dispute?
No, sir.
It is a civil dispute. But this fellow causing the very hectic activity, let him make the end, so they will kill him. When they kill him, if he makes a declaration, it is arising from the civil dispute, but the death is criminal activity. Or attempt to death is criminal activity. So in general, they say criminal proceedings. Am I right?
Yes, sir.
Sir, why killing, even giving the, what I say, a toxic substance? It is enough. Is it not? Toxic substance means poison. Okay, now,
Yes, sir.
the Indian case law is there, Pakala Narayana Swami versus Emperor. It is a Privy Council case law. It is also landmark case law, Pakala Narayana Swami. And the facts of the case is, the deceased received a letter from the accused's wife on 20th March inviting him to her house. The deceased received a letter from the accused's wife on the March inviting him to her house. Okay, later on, what happened? Yes, the deceased left his house on 21st March, informing his wife about the letter. Okay, on 23rd March, the deceased was found dead in a trunk cut into 7 portions. 7 portions. What is trunk? Yes. What is meant by trunk?
Box.
Is it a trunk means box? Found dead in a trunk into the 7 pieces. Is it the trunk is the box or it is the tree trunk, the hole in it? But anyway, that he was found into the 7 portions. The body was identified and the accused was tried and convicted for murder. So now, who invited him for the house, and generally he went over there, perhaps he is the person who killed that deceased into the 7 pieces. So now, where it is gone? Yeah, it is here. So the wife's statement was admissible under the action section 32, clause 1 of the Indian Evidence Act 1872. Why it is running? I want to admit the student because he's waiting. Okay. He was, yes, admissible because whose wife's statement was admissible because he told the wife that he is going to so-and-so person's house. And the statement may be made before the cause of the death had arisen before the deceased had any reason to anticipate being killed. Of course, the statement made by the wife only after the death of the deceased. So such a situation, even the deceased did not reveal the statement, but the wife revealed the statement because those are the last words of the deceased. Is it clear?
Yes, sir.
Even that can be taken into consideration as a dying declaration under Section 32, Clause 1 of the Indian Evidence Act 1872. Okay. Anyone can unmute and read that Kansraj case law? Other participant, I would like to hear their voice. See, there are 11 are there, including me.
In Kansraj versus the state of Punjab, it was held that the statement of the deceased relating to the cause of his death or circumstances of the transaction that led to his death must be sufficiently and clearly related to the actual transaction.
Yes. In the Kansraj versus state of Punjab, the decision of the court, that is, we say it was held, the statement of the deceased relating to the cause of his death or the circumstances of the transaction that led to his death must be sufficiently and clearly related to the actual transaction. If it is such a thing would be there is no unequivocal ambiguity is there. Without any ambiguity, it is very clearly made the statement, and that to be in the same context the deceased was died and what he uttered, yes, it will be taken into consideration as a dying declaration. So, evidentiary value of the dying declaration. The dying declaration is admitted on the principle of, there is a principle is there. The Latin terminology, I quote, nemo maritans proisimitar mentiri. Nemo maritans prosumitar mentiri. It means a man will not meet his maker with a lie in his mouth. So a man means who is going to die, a deceased, will not meet. To whom that he will not meet? Anyone?
His maker.
God.
God. His maker means God, with a lie in his mouth. So that is the maxim, principle. Nemo maritans proisimitar mentiri. A man will not meet his God or his maker with a lie in his mouth. That means he will not tell the lie. He will tell the truth. A dying declaration is substantial evidence and can be the sole ground of judgment. Yes, if it is made in the same transaction when the deceased died. The probative force of the dying declaration depends on the facts and circumstances of each case. How we can take it is a genuine? The veracity. The answer is yes. If he died in the same transaction, in the same context, at the time, even it is a sole substantial evidence to decide the case. If the court finds it is true and voluntary, further corroboration may not be required. When it is made very much clear that a deceased died because of this so-and-so cause of, and he made such a declaration, yes, without the corroborative evidence or without the prosecuting evidence, it will be deemed and taken into consideration. Is a valid, and no other evidences should be established over there. But when required and necessary, it may be corroborated with other independent evidences. If the court feels that is not sufficient over there because it is not showing the absoluteness of that transaction, whether he died in such a circumstances or in the same transaction or not, at the time stands a corroborative and the prosecuting witness, independent witnesses could be taken into consideration. So that is the point which is made. So to whom a dying declaration be made? So I am giving a long answer how you have to make it out. So these are all the points you could make it out. Yes, anyone can unmute and read the to whom dying declaration be made? Yes.
Section 32, Clause 1 of Indian Evidence Act doesn't specify it as to whom the dying declaration can be made. A dying declaration can be made to anyone. It may be a friend, relative, and even stranger. It is to be noted that dying declaration made to magistrate will have high probative force as compared to any dying declaration made to a stranger.
Yes. That means the section 32 clause 1, it did never reveal that to whom the dying declaration should be made. Because that we saw in the Pakala Narayana case law. The person last word is revealed to his wife before he is leaving to the house where the letter has reached over there. But later on he was found into the 7 parts of the torso and fixed in a trunk. At that instance, it is enough that he did not reveal to the magistrate and he revealed to his wife. So here it is said that it is the dying declaration made to a magistrate is having the more probative value. But when it's made to a friend, a relative, even a stranger, yes, you should be known veracity of it, whether it is a genuine or not, then it can be considered. If the court feels that it is a doubtful, then the corroborative evidence as the prosecuting evidence, independent evidence will be taken into consideration. So that is made clear to them. So dying declaration by signs. Here signs means gestures. Spelling gestures. So in Queen Empress, or we can say Regina, Regina, that with the Queen will say in the Latin terminology versus Abdullah. The woman's throat was slit, and due to which she was unable to speak, and she suggested the name of the accused by sign. It was held that the question and signs taken together might be regarded as a verbal statement made by a person as to the cause of his death within the meaning of the section 32 of Evidence Act, class 1. Is it clear?
Yes, sir.
Either you can say signs or by the gestures.
Yes, sir.
It is revealed in the case law of the Queen Empress versus Abdullah, or R versus Abdullah, or Regina, Regina versus Abdullah. I told you in my last class, or earlier classes, when I was dealing the MCQ, after the passage of the 31 years or 32 years of teaching, I did not know what R stands for at the time. But later on I came to know that Regina, or the Queen Empress versus Abdullah, is the title of the case law. So even FIR, what is FIR?
First information report.
First information report. Among the 4 abbreviations and where it stands, I gave you the 4 type of the abbreviations and where this FIR stands. First position, second position, third position, or the 4th position. Sir, we don't know. You are forgetting, sir. FIR means you are revealing or saying or spelling each letter word. Hence, it is called
First information report.
in the stages. In the stages of abbreviation. I gave the 4 stages. Anyone? Abbreviations can be in the 4 types. Number 1, number 2, number 3, number 4. Can you know it? Anyone?
Acronic.
Go in the sequence.
I don't know.
Say pass on.
Pass on, sir.
Number 1, initialism.
Right.
Number 2, acronym.
Chronic.
Number 3, shortening.
Shortening.
Number 4, contraction. So when the initialism FIR is the initialism, like if you want to say Cafe Posa, Posco in one word, or NATO, ISRO, these are our acronym. In shortening, we will say February, we not to write total. F, capital F, E, B, full stop, enough. Even EG, exempli gratia, for example, shortening. And when you come to the contraction, I know, does not, DOE apostrophe SNOT, N apostrophe it. They don't write the entry thing, DOES, does NOT not. It's a contraction. So FIR die as a dying declaration. How? In Mahmood Ilahi versus State of Uttar Pradesh, the court held that a report made by the deceased regarding the cause of his death or the circumstances that caused his death to the police officer shall be relevant under the Section 32, Clause 1 of the Indian Evidence Act 1872. That means a complainant made the complaint to the police station is deemed to be. Yes?
Dying declaration.
It will be taken by the police officer as a FIR. It will be deemed to be a dying declaration. Is it clear?
Yes, sir.
Kolikonda, are you present? Because I made him to come. And the time is 8:35. Still, will you have at least 15 minutes in your hand? So he wants to deal the law of limitation. Venunath, are you present? No, he's not present today. Otherwise, I gave some assignment to him to deal, and which I put it in the WhatsApp group. And I want to ask him to deal on that particular point. When your matter comes to the law of limitation, I made a statement in the beginning. Limitation bars the remedy, but not the right. That I told you. So when you discuss this thing, what is the limitation period for the law of contract? The breach of contract is there. What is the law of limitation?
3 years.
Pardon?
3 years, sir.
Are you sure? Or 6 years? For the government contracts are concerned, it is a 50 years. Okay, let me presume it what is 3 years is the right answer. After 3 years, if a person files a case, means a person who has given the debt to another person, debtor, means a creditor files a case against the debtor, and the plea taken by the debtor is, you did not file it within the prescribed limit of the filing, means law of limitation. So the bars the remedy, but still your right is there. But in certain cases, the court will condone the law of limitation. And at that instance, the person who has taken or the person who is liable to pay, and he should be paid. But if you keep the same proposition in the case of ethical values, but in the necessity, the friend has helped him. At that instance, A moral obligation would be there, even though it is crossed 3 years or 6 years, doesn't matter. You're supposed to return the principal amount with the interest, if the interest is given. If it is a hand loan, no interest. At that instance, the principal amount should be given. So that's, I told you that limitation was the remedy, but not the right. Right is like a energy, and it will not die unless it will be the right ingredients are fulfilled over there. At that time, the right will be extinguished. The right will be extinguished at that instance when the fulfillment of the creditor to the satisfaction of him is there. Of course, sometimes even a creditor may waive the right also. Even if you pay the half of it, I presume that you paid the full. So that is called write-off. Write-off. Just before I told you. Waiver. Spelling?
WAIVER.
Yes. In that way that you can make it out. So, I am alone, but I do have the other things also delete. Shall I start the another topic, small topic? Not topic, it's a bigger one only. Yes. And here, I made it dying declare facts which need not to be proved. Which are facts need not to be proved under the Indian Evidence Act? Of course,
Admitted facts.
Yes.
Admitted facts need not be proved.
Okay. Courtesy from the RQDT Sarkar and is a BLB student and the Law College of the University of Calcutta. The introduction, it says, as a general rule of law, the party to a suit is required to establish his cause before the court by adducing either oral or documentary evidence, which includes electronic evidence. Because of
Information Technology Act.
a pandemic. Even though Information Technology Act was promulgated or put into force or made in the year
2005.
Is it 2005? It is 2000 only, if I may not be mistaken. But at the time, they don't make as a direct evidence. They say corroborative evidence. It goes with the corroborative evidence. Because of the pandemic, it is directly taken as evidence. A person, a doctor who is an expert, he cannot come to the India to give the evidence. At that instance, a conference is made by using any platform, and at that instance, the evidence will be adduced, and he will give the evidence from the USA or any other country, and that will be admitted. So, electronic evidence, however, under certain scenarios or circumstances provided under the Evidence Act 1872, where the parties to a suit are not required to provide evidence in favor of their assertion, they need not to put the evidence over there. In general terminology, in the law of tort, what do you say? In the law of tort, there is a maxim is there. I will give the equivalent English terminology, and you give me its Latin terminology. The thing speaks itself.
Res ipsa loquitur.
I appreciate. Gausia, I appreciate. Res ipsa loquitur. Res, R-E-S, res, space, ipsa, I-P-S-A, ipsa, loquitur, L-O-Q-U-I-T-O-R, if I not be mistaken. So, section, if anybody wants to say anything, because I heard the Gausia, we would like to contribute anything.
No, sir.
Okay. Because I saw speaking. Means you put it on unmute mode. That's why I could see it palpitates on my screen. Who is speaking? Okay. Now section 56 to section 58 of the Indian Evidence Act contains the provisions relating to the non-imperativeness of admission of evidence by the parties to the suit before the court to endorse the credulity of their statement. What is the section? Section 56 2. So the Indian Evidence Act. Indian Evidence Act, I put it here. Then Control F, you can make it out. There is a box is there. Control F. Why it is not accepting? Yes, it is accepted here. Control F, you can put it. Okay, somebody is joining, admit. So, what is the section? Admissibility section? Section
Yes, sir.
36, is it not? Just before we read it. No, it is the 56 to 58 of Evidence Act. Yeah. Contains the provision relating to the suit. It is the 56 to 58. So now let us. You should have the computer. Computer. Say.
Savvy.
SAVVY KSB. Now you are present. I called. Then I am dealing now. Because I did not find.
Unexpectedly, there was a meeting.
Okay, no
An
matter.
apartment.
Okay.
I forgot it. That's why.
Just a message is enough for me. Okay,
Yeah.
let's continue to section 56 to 58, which clearly mention part 2 on proof, chapter 3, facts which need not to be proved. Yes, reader. Read that, section 56.
Fact judicially noticeable need not be proved. No fact of which the court will also, which will take judicial notice, need to be proved.
Means no means here the no is put it over there. That means need not to be
proved.
Okay, number 56.
And this 57th one is facts of which court must take judicial notice. Some facts it must take into notice. The court shall take judicial notice of the following facts. 1. All laws in force in the territory of India. 2. All public acts passed here or hereafter to be passed by Parliament of the United Kingdom. Why is it there, sir?
Yeah, because we directly has taken some laws as it is.
And it was in 1872, the Evidence Act.
Yes.
And all local and personal acts directed by Parliament for the United Kingdom to be judicially noticed. Third one is article of war for the Indian Army, Navy or Air Force. And fourth one is the course of proceeding of Parliament of the United Kingdom of the Constituent Assembly of India, of Parliament and of the legislation established under any laws for the time being in force in a province or in the state.
So, in this way, if you happen to read, there are, can you say it is a class 1 or subsection 1? Anyone? Not the participant, not the host. 57 facts which must be judicially noticed. Still 5 minutes are there. The court shall take the judicial notice of the following facts, they say. Can I say subsection 1 of the section 57 or section 57 of the class 1?
Section 57 of the class 1.
Why?
Because immediately it is not followed after
Number one,
37.
it is immediately not followed. Number two,
And number 2 is it is in italics.
it is in italics. And hence, we should say the class 1. So, class 1 to class 13. Yes. Okay, read the 13 one.
Yes, 13th one is the rule of road on land or at sea. In all these cases, and also on all matters of public history, literature, sciences, or art, the court may resort for its aid to appropriate books or documents of reference. So, in all these areas, the court may refer, for example, if it is public history or literature or science or art, whatever it is, the court may resort to the concerned books, appropriate books or documents of reference on the concerned subject. If it is public history, then it will take the reference books of public history. If it is literature, then it takes into consideration the eminent literary works or that of science or that of art, etc., etc. If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so. So the person the court asked for this should produce the concerned document or book which is appropriate one only. Then only the court will permit to present it.
Yes, that means a documentary evidence should be needed over there, and court will not take the judicial notice of it, as it discussed earlier.
Yes.
So these are the things should be there, and for the first session, and tomorrow Kolikonda Sharad Babu, my teammate, will make it a thorough explanation with the decided cases. The law of limitation bars the remedy but not the right with the decided cases some extent, and add with the some other thing which is connected to the limitation. And tomorrow I will make it the post to you what may be. Of course, the continuity is there, which may take the judicial notice. Just now, facts need not to be proved. I will continue with it tomorrow, and the Kolikanda will make it out limitation and its accessories if any other short questions are there. But I already told you that the question paper, the present question paper doesn't have the grammar. Please ascertain it. Ascertain it, because once, if I not be mistaken, Sandhya or Mamata, who has sent to me the question paper, and which consisting of only the translation and the two narrative type questions. But no,
Then the candidates will be benefited if it is not.
yeah, it is be quite good. Otherwise, no, you have to go through the activas, pativas, direct speech, indirect speech, and sentence structure, false cognates, and direct many other parts, even subject agreements. That also you should have to read it. And many other factors also. If it is, please find out the other type of the questions, what the nature of the question should be there. But the current nature of the question is only the translation plus two essay type questions are there. That's all. And your entire marks will be goes in that way. So I have posted in the group also the same thing, and which is the latest, that is the paper 3 I am speaking about. Am I right? But anyway, that calendar is not prepared over there. If the calendar would be prepared, at least the participants should know what they are going to read tomorrow. But we will try to make it out in the last class. Yes, the facts need not to be proved. Whatever the Kolikona Sharad Babu
Yes,
is
sir.
connected to the law of limitation.
Yes, tomorrow I will definitely deal with it.
Yeah,
sir.
law
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मागे। गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full